Hello, in today's video, we shall be looking at another aspect of factual causation. Another aspect of factual causation, or causation in fact. We had looked at the general rule regarding factual causation and concluded that the but-for test is the general rule that the courts would apply. We had also established in previous cases that sometimes that but-for test may prove inadequate or unhelpful to the court, especially where you have multiple causes. In today's video, we are looking at factual causation in the context of uncertain or indeterminate cases where you are unable to even identify the cause of the injury because there may be two or more potential or possible or probable causes of that injury. And effectively, to do that, I'll be sharing my screen as usual. In this respect, we are still on the question of causation in fact. Causation in fact. And because the court inquiry is trying to determine the defendant, the appropriate the person to sue for a particular injury. Now, our learning outcomes in this presentation are threefold. To understand and apply the rules of causation, where the cause of the injury is uncertain, with two or more causes, what we normally call the one-hit-hunter cases. Understand the scope of the rule in Fairchild's case, where we talk about material increase in risk. Then be able to understand and apply the limits of the material increase in risk approach that was established in the line of cases regarding Fairchild, where you have causes of injury that are more than one and the same agent, as caused by the same agent, and you find it impossible to determine the causation on a balance of probability. Now, what are we talking about here? The classic example of case scenario is what they call one-hit-hunter case. Find these facts in Cook and Lewis and Summers and Tice, Canadian cases, where in hunting accidents, one bullet hits the plaintiff and each defendant had fired in the plaintiff's direction. Now, from onset, I would say that it's been held that both of them would be liable. Let's take the cases. Lewis and friends, for instance, in Cook and Lewis went on hunting trip, and then Cook and Arkansas fired their guns at birds almost simultaneously. At the end of the day, Lewis was shot and he lost an eye. Now, each of the defendants, Cook and Arkansas, both argued that they only shot at birds, they didn't shoot in the direction of Lewis. And it was impossible in the light of the facts to know which of them actually shot him. The court held that each of Cook and Arkansas committed it wrong, a tort against Lewis. And that since it was possible in the light of the facts to determine which of them, whose bullets actually hit him, both will be liable. Now, these are usually cases where you are unable to ascertain upon the facts who is responsible. If there is any probability that either was the one that hit him, assuming, for instance, in the light of modern evidence, you can show that the bullet of Mr. Cook was the one that hit him or Arkansas, then that person would have been exclusively liable. But in the face of the lack of that evidence, both were held liable. The same thing in Summers and Tice. And the court held it on similar facts, not being able to determine who is the responsible defendant. Like I said, one of the ways to remember it is what we call the one-hit-hunter case that I have here on the slide, where the bullet that hits the man is just one, but two or three or four causative agents have been established. Naturally, in practice, each of the defendants responsible for that causative agent would argue that but for my injury, I was not responsible. And if you apply the but-for test, it will not be at fault. Because if you apply it, every one of them will escape liability. So the court said in Summers and Ties that if a plaintiff cannot show which of two tortfeasors is the cause, in fact, of an injury, the burden of proof shifts to the defendants to prove they were not the cause. So in each of these examples where two people fired in the direction of the plaintiff and he was injured, and you could not determine who is actually the one that hit him, the two of them liable, because law would rather compensate a victim than allow two probable defendants, two probable tortfeasors to escape liability. One of the things you must notice that, of course, the evidence must have excluded the fact that that injury could have been from another person, third party, or from any other source. So it must have excluded, examined that possibility. Then you have Fairchild and Glenhaven Funeral Services Limited, a 2000 case. The plaintiff sued for exposure to asbestos dust. These are cases where you find a victim who had worked for several employers. He had worked for several at different times, and they had all exposed him to asbestos dust. And so when he contracted mesothelioma, a form of cancer, how does he prove which of the employers' exposure, that is breach of duty, caused the injury? Under the employer's liability rules, employers are supposed to provide a safe place of work for their employees. So when you have people working in a particular industry, there is always some risk attendant to that. And most of the cases in those areas, you find employees unable to establish scientifically which exposure caused injury. The House of Lords held each employer liable if the claimant proved that each had materially increased that he would contract disease. So you have cases where the person would have worked for so many of the employees, or two or three, and the court would find that as long as they had materially increased the risk, since they had worked for them, maybe sometimes you have employees that have worked for 30 years, and after that they manifest a particular disease that is domiciled that industry. Unless science has developed to the point that it can isolate the point at which the injury had occurred, all employers would really be liable. So the Fairchild case affirmed the principle in McGee against National Coal Board, which held that where you have materially increased the risk of contracting the illness or disease, then the defendant would be liable. Materially increase the risk. If the exposure, for instance, someone that works for 30 years in a setup with 3 employers, and evidence shows that for one employer, he only spent 1 week because he wasn't satisfied with the payment. And then the other 2 employers, he worked for 15 years, he worked for 13 years. Then it might be possible to say we can ignore the 1 week that he worked. So with the first employer, the risk will be regarded as immaterial if the negligent exposure had been too insignificant to be taken into account, having regard to the overall exposure. The Fairchild decision therefore established that the employer had materially increased the risk of the employee contracting a disease. And this Fairchild case, well, it was exposure to mesothelioma. It is not limited to cases of mesothelioma. It is not limited to that. It could actually cover any kind of exposure in any kind of industry. And it has been held that it is not even limited to where the exposure is from a third party, even where the claimant was one that exposed himself. So Fairchild is not limited to cases of subsequent tortious acts. In McGee, which was a dust case, there was no subsequent tortious act that they were comparing. There was no subsequent tortious act. In Fairchild suit, the court approved decision in Musha's case that we have considered in the previous video. It approved it, but it distinguished Fairchild in the sense that Fairchild's case is limited to injuries from one causative agent. For example, asbestos. That was the exposure in Fairchild's case. So where the causative agent is not the same, Fairchild felt it would not be able to help a plaintiff. You may have to look at other causes and rules. Fairchild is not limited to mesothelioma cases. Like I said earlier, cases where people are exposed to and they are now eventually contracting cancer. If you look at McGee, for instance, a national food board, it was exposure to dust. It wasn't exposure to mesothelioma. So it could apply to other kinds of exposure. But the courts have tended to look at it that as long as the positive agents that you are talking about is the same, that this agent, that employer A, employer B, employer C exposed the person to this agent, for instance, mesothelioma, and that agent is the only thing that could have caused the cancer, then the employers would not be able to escape liability. They could be held to have materially increased the risk, contributed to the risk of injury. McGee that we are talking about, we talked about it in previous videos, but this was a case where the employee was exposed to dust throughout his work and he developed dermatitis. And it was also taken in evidence that apart from the fact that he was exposed to it at the workplace, they did not provide waiting facilities for him at work, and he had to cycle for a long time before he could get home. So the exposure at work was one thing, but the fact that in breach of their duties to their employees to provide safe place of work for that kind of environment that they needed waiting facilities, it was part of their statutory duties to do that. But the employers, they argued that they were not liable on the premise that the evidence was able to determine whether it was because it was exposed at work that contracted dermatitis or because he did not shower and and had to go home, before he could shower. So that was their argument that when you're able to determine that the probability was there that they were not liable. The court held that the defendants, by failing to provide those washing facilities, had materially increased the risk of contracting the disease. So you might ask yourself the question, in practical terms, perhaps there are employees who had washing facilities in their own place of work, and they didn't, for instance, develop dermatitis. That would be a way of establishing practical terms whether it was the fact that McGee had to travel for some distance home before he had his, before he could shower, that actually caused him to develop dermatitis. If there was evidence like that, scientific evidence, it should have, look, all those ones, or employers who provided washing facilities, none of them developed it. It would have put the case on a different pedestal. The court held as well, we cannot establish that. There was no evidence to suggest that, which I am making as a position. So the court felt that, well, you had materially increased the risk, so you should be liable. Then you have Baker and Koros case, which applied Fairchild decision to cases of subsequent tortious activities and even self-exposure to asbestos. In the facts of Baker and Koros, the defendants had exposed the plaintiff to dust while working for them. Again, that was a breach of their statutory duty of care. But the plaintiff also worked for himself in the same industry, established his own business and worked for himself. And so the question was, this is also a place where there is the same causative agent, asbestos. One was caused by exposure of the defendant in breach of the duty of care. One was caused while the plaintiff was working for himself. The courts applied the professional liability rule. You know, in Fairchild, they were held responsible entirely. But in Baker and Koros, the House of Lords, they applied the proportionate liability rule and said that, look, they will be liable for the portion of the degree of their wrongdoing. So, assuming the defendant had employed the plaintiff for 20 years, and the plaintiff worked for himself for 5 years, the damages will be proportioned in that regard. And the plaintiff will only be responsible for that portion that can be ascribed to his own degree of wrongdoing. Now, in English law, in England, the Baker principle had been reversed by the Compensation Act of 2003 with respect to mesothelioma cases, which talks about proportional liability. Any case that deals with mesothelioma, the issue of proportional liability will not apply. So all the employers will be liable. Okay? The danger that the legislature saw in proportional liability was that if you say, for instance, a plaintiff had worked for 4 defendants, and they have all exposed him to the same causative agents. For instance, asbestos. And you now sue, and only one of them is available, and that person is only 5% exposure. That means it's only 5% of the damages is payable by that first defendant. Let us assume that the 3 other defendants had gone out of business. The plaintiff remains absolutely undercompensated. So what joint and several liability does, as espoused in Fairchild and some other cases, that it makes the first defendant liable for the entire injury. That defendant can go ahead and sue for compensation for contribution rather, from the other 3 that are outstanding. But that would be a case between the 2, within the defendants, amongst defendants rather. Plaintiff would have received his own compensation. This can be explained in the light of the principle of the theory of corrective justice that tort law is founded upon. Okay. Now, the summary of what we are saying is that when it comes to factual causation, the but-for test, the general rule for factual causation, may not be helpful in cases that we call multiple causes, where it is impossible to determine or define the cause of injury. What we have called the one-hit hunter cases. One-hit hunter cases, meaning that in the example that we have seen, 2 hunters shoot in the same direction, 1 bullet hits the plaintiff. There's no evidence, factual or scientific, as to which bullet hit the plaintiff. If we apply the but-for test, hunter A will escape liability, hunter B will escape liability. That's the case. That's one premise. Now, to help in determining such cases, other rules have emerged beyond the but-for test. Now, these cases of indeterminate causes are either that there is a wrong to another wrong, or a natural cause setting 2 or more wrongs. A wrong and the action of the claimant can also be in contemplation. You can see that in Baker and Koros, where the wrong was 1 on the part of defendants, then the claimant too had exposed himself to asbestos. Most cases, the court would apply joint and several liability to hold whichever defendant is available jointly and severally liable to be responsible in actual fact for the entire damage. There are exceptions to this rule, this general rule called the Fairchild exception. Now, the idea is that where the defendant had materially increased the risk of the plaintiff contracting or getting that injury, the defendant would be liable. So the defendant does not have to be the sole cause of the injury. There may be other causes, but if you have materially increased, then you will be liable. The Fairchild exception is not confined to mesothelioma cases of cancer. In McGee and National Board, that deals with exposure to dust. So the case of Baker and Copus established the fact that instead of absolute liability against one defendant who caused a percentage of an injury, should have proportionate liability. If it's found to have been 60% contributory or 60% increasing the risk of the injury, then its liability should be limited to 60%. That was the contribution of Baker and Cooper's view limited. However, since that case, the United Kingdom, by their Compensation Act, had reinforced joint and several liability for defendants in cases that deal with mesothelioma-induced injury. Mesothelioma-induced. In such cases, joint and several liability continues to apply. That is, if you have one defendant or two, they are going to be responsible for the entire injury. But proportionate liability continues to apply to other cases that are not relating to mesothelioma. Proportionate liability as seen in a lot of the cases. In conclusion, what we are saying is that in cases that deal with negligence, as I continue to emphasize in this series of videos, you must find out, having established duty of care and breach of duty, that the injury that we have before us, a broken leg, death, cancer, dermatitis, any kind of injury that you are now talking about, can we say that factually it is the breach of duty of the defendant that caused it? Where you have one defendant, one positive agent, it's very straightforward. But when you have multiple causes, multiple defendants that are probable, or other acts or omissions, it may even be from the plaintiff himself, from third parties. You need to apply different other rules beyond the but-for test. So in the series of videos that deal with the but-for test, multiple causes, and this one that deals with indeterminate causes, we have examined the legal issue as to whether, as a matter of historical fact, the injury to the plaintiff was the result of a breach of duty by the defendant that is before the court. If we find out, as a matter of historical fact, that that breach of duty is the cause, then we proceed to the next stage of inquiry and determine whether we should hold that defendant legally responsible for that injury. Legally responsible, legal causation. That is another consideration that will be taken in subsequent presentation. However, remember that I emphasized the fact that sometimes you may not need to establish causation if you rely on the principle of res ipsa loquitur, which we should also look out for in subsequent videos.